Mr. Billingsley. Is Mr. Billingsley here? Come on up, Mr. Billingsley. This is Cody Billingsley.
The problem. Okay, so then we need to.
Step on up, Mr. Billingsley. Gentlemen, can Mr. Billingsley have the podium? This is 24M350. Mr. Billingsley is here for admit deny on a petition to revoke probation. He was sentenced December 17th for DUI and child abuse and was given a deferred judgment and sentence for 15 months. On September 26, 2025, a petition to, sorry, I got distracted for a second. September 22nd, 2025, probation was revoked and reinstated. And now we have a new petition to revoke on May 13th, 2026, alleging positive tests, failed the test, no outpatient therapy. And Mr. Billingsley was advised on June 1st of the allegations. Ms. Diddleberger?
Yes, Judge, I would defer to, or I would ask the court to ask Mr. Billingsley like what he'd like to do in this regard, whether he'd like to admit or to deny and set this for a hearing.
Okay. Mr. Billingsley, do you understand the situation we're at?
Yes.
Okay. We are here for what's called an admit deny today, which means that you could admit to the allegations. You could deny the allegations. You could admit the allegations and we could either set over for sentencing or proceed later on, or or you could deny. You could deny and we'll set for a hearing. Okay. However, I have one question to ask you before we begin this, Mr. Billingsley, and that's the deputies are reporting that they believe you have the smell of alcohol on your breath. Are you intoxicated or did you drink this morning before you coming into the court?
No.
Are you willing to take a breathalyzer to prove that to me?
Sure.
Okay, let's call up a PBT. Deputies? Mr. Billingsley, I'm going to have you have a seat, okay, while we wait to do that, okay?
Okay.
All right, thank you. Don't leave the courtroom, Mr. Billingsley. All right. Don't leave the courtroom, Mr. Billingsley. Stay with the deputies, okay? Mr. Showalter, do you have Brooke Henderson? Is she going to be here today?
She is, Judge. She's
Great.
here.
All right.
She's live in person.
Let's pick Ms. Henderson's case up. Cases 24M860, 24M443, 25M27. Ms. Henderson, one of the first cases I worked on when I was on the bench. Ms. Henderson, so remind me, so I went through all this. We've currently on a petition to revoke in 443. She admitted probation violations in 860 and M27, and we're set for resentences to that. I allowed her to go to rehab on March 9th, 2026, and she was supposed to report to probation on release. So how did she finish the rehab? Where are we at?
I think I know as much as the court does. I'm catching up also. We kind of caught up this morning.
That's good.
So it's good news. It's good news. She's doing great.
Okay.
Yeah, she completed the.
You were supposed to do 90 days? Okay,
Yeah.
all right.
I don't think she did the whole 90. She did, I think, 62, but.
62 inpatient, but
Okay.
I did do 90 days.
Okay.
Total.
Yeah,
Okay.
I completed the Mountain Springs
Okay,
detox, residential,
Okay.
PHP program, and IOP program.
okay. So with all this in mind, Ms. Diddleberger, what would you like to do?
So first, I think, so I'll let the court know the information I have from probation, which is similar with something to add. She completed 63 days of a program that included detox, that would point to her showing up with alcohol in her system, inpatient, partial hospitalization, and some IOP. She was discharged from the program due to taking approved leave and not returning when leave was over. She would still be in the program, but she lost her scholarship. She is on a SoberLink, which is a handheld breathalyzer. She had a confirmed positive test on June 9th. If she admits, probation is going to be recommending revoke and reinstate with 2 years, and that the court would direct her to get on an ankle monitor for 60 days, and that she would be transferring her supervision to the Denver area and Jefferson County.
Okay,
So that's the information I have for the court.
so she would be admitting to,
Sorry, she's on 2, she's getting resentenced, so she's already admitted.
right. So that's in M860 and 25M27. I've got that she already admitted the probation violation. We're here for resentencing. And then we
Yes.
have M443, which is currently still an outstanding petition to revoke. So.
Right, and in
what
that
are-
one, we're not, we'll just keep continuing that one because we're not asking for conviction to enter based on the allegations in 24M 860.
Okay, are you revoking, are you withdrawing the petition to revoke in 443?
I'm not withdrawing, but nor am I asking for it to enter.
Okay.
So I'd ask for these to trail the,
So and again, I'm sorry, sometimes I get tripped up on how these things procedurally work.
that's,
So we've got,
Because you can always refile it.
that's true, I could refile based on, so I'll withdraw the motion to, let me see exactly what it says before I
Because
withdraw.
I think we're all looking for some closure today, and certainly if she's going to be back on probation.
but it would sound like the resentencing would be to revoke and reinstate for another 2 years in M860 and 25M27.
Right,
And then it sounds like probation will transfer her down to Denver because she's moved down to the Front Range, right?
right.
But that's outside of I don't order that. That's something probation does. And then the petition to revoke would be removed in 24M 443 because they could always refile if she ended up kind of falling back off the wagon.
That's my understanding, and I believe we are in agreement with that. Does that sound, okay, I think we're in agreement with
Ms.
that.
Dittelberger?
The only issue with that, Judge, is that it's probation that filed, so I'm not gonna actually
petition to
withdraw
revoke.
that until I hear from them. So I would just ask for a lengthy setting on that.
Okay, Ms.
A couple
Botsford?
months. Oh,
Ms. Botsford, you here on her?
Yes, I
Yes, thank you, Ms. Botsford. So,
I would be in agreement to withdraw that petition.
Okay.
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 You can always refile if needed.
Okay.
This helps us to be able to transfer everything.
Okay. And Ms. Botsford, is probation satisfied with what they're saying from Ms. Henderson at this point in time?
Yes, I am, Your Honor.
Okay, all right, okay. I'm glad to hear that. All right, then I will go ahead and do that. On M860, I will do a revoke and reinstate. We'll revoke probation and resentence for another 24 months of probation on the same terms. And we will do the same thing in 25M27. I'll revoke Ms. Henderson's probation and reinstate for 2 years, 24 months of probation on the same terms. And then in 443, the petition to revoke is being withdrawn. So do I need to do anything further on this one, Ms. Dittelberger or Mr. Showalter?
No, Your Honor.
No, Judge, no.
Ms. Botsford?
Yes, it just makes sure that she has that ankle monitor for 60 days.
Okay, that's something I need to order as part of the probation?
Well, I think
Or is that just something probation? Okay,
she does have a sober link.
okay.
We need more.
Okay. And is that something can she do that down there or?
She can do it once she gets on the front range.
Okay, all right, all right.
Just, waiting for information
Okay.
from them.
Then I will make as a condition of probation,
Yeah.
60 days on the ankle monitor. Does it need to be a scram unit that tests for alcohol as well?
It is.
Okay, okay.
Scram is an ankle monitor. A sober link is a handheld.
The handheld that I have is Scram.
Okay, so what it would be is.
It would be an ankle monitor that tests for alcohol. Is that right?
Yes.
Okay, all right. Then I'm going to impose 60 days on an ankle monitor once she returns to the Front Range and signs up with probation there. Okay? All right? Ms. Henderson, I'm very happy to see you're getting things back on track. Okay? It's not easy and there's still going to be some bumps in the road, but you're making it, just keep it up. That's all I can say is that keep working on it and keep working on it every day. All right? Okay, but I'm very happy to hear this. I know, we had some rough spots. Like I said, you were one of the first cases that I kind of had that I really kind of struggled with on how to handle things. So I'm glad that we hopefully came up with some solutions that are going to straighten things out for you, okay? All right, good luck.
Thank you.
Anything further, Mr. Showalter?
No, thank you.
Okay, I think I'm done with you. Do I have you back at 10?
You are, Judge, yes.
Okay, thank you, Mr. Showalter. All right, let's return to Mr. Billingsley. Mr. Billingsley, this is 24M350. Deputies report a blood alcohol content of 0.053 for you on the PBT. So I'm going to remand you into custody as a violation of your bond, and we will set you for tomorrow at 1:30 for further proceedings on this. Okay, thank you, Mr. Billingsley. This is 24M350. Mr., did you have any? You were here for, all of a sudden I blanked your name. I don't know why I have such a hard time. Mr. Berggren, any comment or? Okay, all right, we'll see you tomorrow afternoon, Mr. Billingsley. Thank you, deputies.
Thank you. Okay, we're here on, let's see, 24M113, 25M49. Mr. Moody did waive his appearance, but he appears by phone. Council, Ms. Young's here in person. Ms. Beaverson's here on behalf of the people. We're set today for a pretrial readiness conference. These two cases are set for jury trials July 7th for 24M113 and July 8th for 25M49. The people filed motions to dismiss these cases on June 5th and June 9th. And the court issued an order June 10th setting the hearing for today. Setting the hearing is really for the purpose of the court making a point. The court has essentially very limited or almost no discretion to deny the prosecution's motion to dismiss. It's a separation of powers issue. And the prosecution being in the executive branch, the court being in the judicial branch, the court doesn't really have the opportunity to second guess the prosecution's decisions to dismiss unless there are some specific concerns. There is, under Rule of Criminal Procedure 48, there's a version where the court can find by clear and convincing evidence that the interests of justice or the interests of the defendant are jeopardized by the prosecution's refusal to prosecute. The court can find under 165209 that the refusal to prosecute was arbitrary or capricious and without reasonable excuse and require prosecution through the appointment of a special prosecutor. The court is not going to do that here, but the court is very concerned with the reasons that were given for the prosecution here. The idea that because an individual is set for trial on similar conduct, that these cases would be dismissed in the county court before that trial is resolved. It would be a very different situation if there was a conviction, if there was a sentencing set in the district court. But if that trial is unsuccessful for whatever reason, perhaps a procedural reason, any number of reasons that trial could be unsuccessful from the prosecution side, then the victim, the alleged victim in this case, is left without recourse for what is alleged to be repeated behavior over the course of a number of cases. That's one concern. The other concern is that Mr. Moody has been appearing in court on these cases for years. And there is a pattern that is apparent of cases being set for trial and then those cases being dismissed. There's a reason why we are often sitting here in this courtroom with nothing to do, and that's because of the number of dismissals. And Ms. Beaverson, I know you've told me that's because you have more of an opportunity to review the cases than other attorneys in your situation have. But it is concerning to this court. It's concerning to other judges in this district, the number of dismissals that we're seeing, particularly the number of dismissals on cases that are set for trial. That's my soapbox for the day. Like I said, I have very limited discretion to deny a motion to dismiss. I'm not going to require a hearing. I'm not going to attempt to make the findings that would be required to put the court in a position to deny those motions. So I will grant those motions at this time. In 24M113, the case is dismissed. The jury trial that's set for July the 7th is vacated. 25M49, the case is dismissed. The jury trial set for July the 8th is vacated. Anyone have anything they want to say? But while we're still on the record with these cases.
I just have one thing to add to the court's record there. With respect to the conduct that underlies the there were two cases left. There was a third case in misdemeanor court that was already dismissed by Deputy Bryce Martinez because that was brought into the other case. And there was a reason strategically to not bring in the violation of protection order in this case. And given that the other count that was on, so we would have had a violation of protection order set for trial in one of these cases, that particular contact was not included in the felony case strategically for purposes that the district court prosecutor decided. With respect to the other VPO that was pending, the people did not see it was in the best interest of justice. That was an allegation of drinking on a protection order. And it came back, it was also wrapped in with the driving under the influence. So that came back as a really minor amount of alcohol. And we just didn't think that that case really had that much success forward-looking on with the jury, given those results. So I just wanted to add that for the record, but we appreciate the courts, the people appreciate the court letting us know this, and we'll be looking towards refining the docket management and seeing what we can do. But I understand the court's perspective.
Okay. Well, I appreciate it. And again, it's not only specific to this case or the circumstances of this case. It's a general pattern. Like a lot of things, the pendulum swings different directions. We've had, Ms. Young's been here throughout this time. We've had a period of time where it looked like we needed a second whiteboard because we had so many cases set for trial. That was with a particularly zealous public defender who was setting nearly everything for trial. That's one extreme, and I feel like now we're at the opposite extreme of that. But the people are entitled to make the decisions that they want to make. But sometimes sometimes the court has concerns, that's all. Mr. Moody, you're all set? You have your district court date set? You don't have another case, another appearance here in the county court? I wish you the best.
Thank you, Your Honor.
You're welcome. Your name, sir? Thank you. Okay, let me see. Let's take a look here. Oh, we can call your case early? Yeah, if you want to come up to the podium here. This is 2026 T70. Mr. Vanderhayden's here in person, appearing without an attorney. Ms. Beaverson's here on behalf of the people. We're set today for a status conference. And let me take a look if I have any notes about why we did that. Oh, I think you were looking into some things on your side. Do you have anything that?
I wasn't actually able to get there. It took about 2.5 weeks for the officer in Monte Vista to get back with me. And then my wife's car broke down.
Okay.
And life's been really lifing.
Okay.
So, but I was driving, you know what I mean? I just don't know the background if it actually was holding, because I believe New Mexico registration requires you to electronically hold your insurance. So the truck is registered and that's what it said on the ticket. So it should be holding it. And I was paying the guy for it and now he's disappeared and tried to say I stole the truck, and I have, chime room seats, and I just wasn't able to get the printout from the report when he called her, and the officer told him that it'll be a civil thing and you have to go through civil court because there is evidence that I've been paying him for said truck, and which is a whole outside thing. But
the officer told the person who sold you the truck?
Yeah, exactly.
Okay.
So I got hit in the ear last night at work.
Okay.
So this half's kind of dull.
Okay. Well, what would you like to do? Are you asking for more time?
I mean, if I could get it, I got everything settled now. I got the wife's car fixed and everything like that. So we're back to having a legal insured vehicle to use in order to obtain these.
Okay.
But I understand I already asked one. So, I mean, I appreciate the leniency, but.
What would you'd be trying to get in touch with the previous owner to see if he had insurance?
No, I have the file for Replevin.
Replevin, okay.
Yeah, I have that and I'm going to file that. But because of my wife's Jeep, I don't have the other 350 or whatever it is to file the second part of it. So I'm going to get the ball rolling today with the first $94 or whatever. And then I'm trying.
The Replevin is for what? The vehicle is,
Yeah,
you don't have it?
Yeah, I mean, I've paid this guy already $2,900, but then now I find out his mom actually is the registered owner and everything.
Okay.
So my thought is if I can get a contact with her, we can work something out. I can just get the title and we can be done and move forward. But like I said, that's what I'm trying to do with this whole thing.
Okay. We're just trying to follow along here. So you have the vehicle.
Yeah,
But you don't have the title.
yeah,
And the replevin is for what? To get the title?
correct.
Okay.
So that we can just move forward. The guy kind of, I don't know, some people nowadays type of deal.
I see. And that was for the replevin. And then what was the other thing that you were wanting to file?
I think it's I have it right here. I guess it's just the complaint to summons and come in court about it.
Okay.
But because, I mean, if they're not gonna give me the title, or I want to give them $600 more, which is the Kelly Blue Book of it, you know what I mean? Be fair. But if not, then I want to sue back for the money I've already put in, or at least the portion that went directly to him. Cause yeah.
And the mom, who's the registered owner, is in.
Yeah, that's what it
She's in New
says.
Mexico?
Correct. That's what it says on my ticket here. So then it's hunting that down. Yeah. Smith, Yana, Mexico.
Okay.
874. That's what I was saying. Registered owner, which is his mom.
Let's see. So I can't give you legal advice, but from what you're telling me, it sounds like a person in your situation would need to file that in New Mexico. Is that what you're planning to do?
Is that right? Okay.
In
I
general,
mean, that makes sense. I mean,
in general, if you're talking about replevin, you're talking about a physical piece of
Okay.
property. You have to
Okay.
file it where that physical piece of property is located. That's in general. Like I said, I can't give you specific legal advice, but
that makes sense.
that I think that would be the typical situation.
Okay.
Ms. Peterson, what's the people's position, the request to continue?
I'm sorry, what was the case again?
26T70,
Name?
Vander Hayden.
Struggling to find that one. Set at 11.
Set today at 11.
Say the name again?
Vander Hayden, there's got two words, Vander.
Okay,
Yeah.
let's just get the case number. I don't have that on.
Okay, 2026T70.
So do you have the documentation?
I haven't got to because my wife's Jeep going down. It took 2 weeks, and by the time the Monte Vista police officer called me back to get the copy of her report from talking to Kyle Smith over the truck, her Jeep's down. I had to borrow a work vehicle just for getting us to work, but now we're back up. Now we're, able to move around. But I mean, I totally understand. I mean, I just didn't know, A, because I didn't have the title, that I could have insurance on it. But B, I was paying this guy to have insurance on it. And then with the ticket saying that it was registered right now, I mean, it had insurance, and I just can't get the car type of thing because these people pretty much disappeared. But I mean, I understand the actions are the actions. I just maybe would like a little leniency on it, if anything, because all my mess is why it happened, but I still was driving, and I understand that.
So your mess is, the truck was titled to this other person who you still haven't gotten the truck from?
Yeah, well, no, I haven't gotten title from. I have the physical truck. And that's why it broke down for Monte Vista that I have chime receipts, have the physical truck. We did a lot of, unfortunately, we didn't do it on paper. And they said we got to go through the whole civil court side of it, which I thought was this, but it does make sense that because it's registered in New Mexico, but I just didn't know because the purchase was here. You know what I mean? And that's where I didn't know, but they gave me a little card. I just haven't had a vehicle to get to Alamosa without taking the chance to do this all over again.
Mhm.
So you do not have conclusive evidence of insurance for the 2004 250?
No more than the fact that it's registered in New Mexico to these people right now.
Okay, the people aren't going to make an offer to dismiss or anything like that.
Okay. The request was for more time. That was my question for you, was whether you,
Well, the people don't.
But, and that's my question. I mean, at the end of the day, I mean, I don't know what information I bring up quick enough to where you know what I mean? And so I understand, you know, the
Yeah.
consequences to actions and such. I just, hopefully in those consequences, maybe I get some leniency, you know?
It's, yeah, if you want to just get it over with, it would, I'm understanding it would be a plea to the charge. So that's a minimum, it's a mandatory fine of $500, and then plus some court costs. So comes out to 7 something when the court costs are on there, I think. You don't have to pay it all. You could make an arrangement to pay it over time if you think you'll be able to come back in a month or two and present something that would show the vehicle was insured on April the 10th, or that you had insurance, or that you have it insured now. That would cut that fine in half.
So if I guess I'd be asking you legal advice on, I mean, because that's my question. If I don't have a title, can I insure the vehicle? I mean, that's my biggest thing. I didn't know. I mean, we have insurance on the Jeep and stuff, you know, so I just didn't know if I don't have a title to give them, I don't want like some theft by receiving type deal, you know?
Right. But if you're the one driving it, you're the one responsible to have it
Okay.
insured.
Okay. Understood. Yeah.
So it's up to you. If you want to
Yeah,
resolve
if
it
I
today, pay it, take a fine. If you want to try and take some time, see if you can get some documentation to either show that it was insured in April or that you have it insured now, that would change the outcome here.
Okay. Yeah. If you guys would grant that little bit of time.
Okay. All right, you're driving another vehicle that is insured, so let's give it a couple months. Let's come back in August. How about August 17th? And at 10:30. August 17th, 10:30, continued status conference. And like I said, I can't give you specific legal advice. If you had a contract here, maybe, but when we're talking about replevin, we're usually talking about where whatever the thing is physically located. If that physical thing is located in New Mexico, there's a good chance that New Mexico would be
Oh, no, it's here.
the title.
The title.
The title.
I see. Okay.
Yeah.
I got you.
You're asking for replevin of the title. So yeah, I don't know. It's a complicated one, obviously. And good luck with everything.
Life's been lifing, man. Life's been lifing.
Yeah. We'll see you in August.
All right. Thank you, sir.
You're welcome.
All right. Good morning, everyone. We're going to go ahead and go on the record. Court's going to call case number 25 CR 136, People versus Yvonne Woods. I'll take entry starting with People.
Good morning, Your Honor. Darren Kafka up here on behalf of the people.
All right. Good morning.
Good morning, Your Honor. Tom Ward appearing on behalf of Yvonne Woods. Ms. Woods' appearance for today is waived.
All right. Good morning to you as well. The matter was set today for a return on 2 SDTs. They were issued. The court had previously entered an order concerning the one to CBI. And so the court will rule on that once it completes an in-camera review. The court did review the motion to quash that was filed by DPD last week. It looked like there was a couple issues in regards to the subpoena to the Denver Police Department, specifically the scope of what was being requested. There were confidentiality concerns, privilege concerns, but I think as a starting point, the court wanted to hear, Mr. Ward, from you. Have there been any discussions or any narrowing of what you're specifically seeking from DPD with respect to that subpoena?
There have not been any such discussions. Their motion to quash was filed very recently before today's court date. I'm happy to have those discussions, and I've expressed the same thing to Ms. McCarty with respect to the CBI subpoena. We may be dealing to some degree with kind of we've got a belt and suspenders situation, since both of the subpoenas seek the exact same materials as drafted in the same language, just from two different parties that we believe are in possession of them. I think what I would ask is I don't know if the court intends to issue a similar order with respect to the DPD subpoena. I do appreciate having been given an opportunity to respond in writing to the CBI subpoena. I wanted to ask for a brief extension of the Wednesday deadline to file that, only because I am going out to California this evening and I'm planning to spend Tuesday and Wednesday driving my son back from college with his car. So it'd be a little hard for me to put much work into it. But even one day, I think I could have something filed by the end of the day on Thursday. I know Friday is a court holiday.
Okay.
So what I anticipated doing was filing a consolidated response to both of the motions to quash. They're not identical in the issues they raise, but similar enough that I think one response from us would cover it.
Okay. Do we have counsel for DPD present?
We do.
All right. Good morning, sir. Do you want to just state your name for the record?
Andrew Owillicki, registration number 27722, of the Denver City Attorney's Office on behalf of the custodians of records of the Denver Police Department and the Denver Crime Lab of the Denver Police Department, which it so happens are the same person.
All right. Good morning, sir. This is what the court was intending on doing today. I was going to ask that counsel for DPD and defense counsel confer, see if we can narrow the scope of what is specifically being requested pursuant to that subpoena. I know that there was a request for an additional 4 weeks to gather those records. Sounds like it's a voluminous amount of material. I would give DPD the opportunity to gather those records. I had previously entered an order for the CBI records whereby I directed them to file the subpoenaed material under seal, and the court was intending on reviewing it in camera to determine what, if any, materials should be disclosed. So again, what I'd like everyone to do is I'd like defense counsel and counsel for DPD to confer to narrow the scope of the subpoena. I'll give the additional time to gather the materials, and then I would like you to file them under seal with the court. Court intends on reviewing those in camera.
All right,
Okay?
that's fine.
Okay. Is there anything else we need to address with the subpoena this morning?
I guess the only thing I would ask with respect to the court's order is the 4 weeks that they're requesting, the amount of time that you're giving them to deposit the records.
Okay. Do you need, is 4 weeks? We're coming up somewhat quickly on trial dates, so I'm mindful of that. If the court gave you 2 weeks, would that be sufficient given the work that you've done? And hopefully the discussions again are able to narrow down these records that are being requested.
It might be possible if it's narrowed down, but if it's not, I've got 280 plus emails that each have to be reviewed, called for duplicates, redacted as appropriate, claims of privilege made as appropriate to each email. And then to the extent that the raw scientific data is within what is being sought, the files, each file is quite a complex thing. It has a couple summary PDF files, then it has a whole bunch of Excel files with the output from each gene locus, and there are about 100,000 genes that are studied for each sample. And then there are proprietary software and additional files and folders that only make sense if you are a hardcore computer programmer, but they are, the sum total is about 49 megabytes, and redacting them is not too much of a challenge. There's probably a name of a crime victim and a CODIS number that need to be redacted for each, but aside from that, not so much to redact, it's just a matter of the logistics. Probably what we would end up doing is putting them on a thumb drive and making them available, because I'm not sure there's any, I mean, there are file formats I've never heard of,
Yeah.
kind
Okay.
of thing.
Okay. What I'm going to do is this. Again, I'm hopeful that the discussions will help us narrow the scope of the request. I'm going to set the deadline towards 2 weeks. However, I'm mindful if you need additional time, if you can just file something briefly with the court requesting an additional 2 weeks, I would intend on granting that. But I'd like to set the deadline for 2 weeks and see if we can get that done.
Certainly will make a good faith effort to do so.
All right, I appreciate that. And then, Mr. Ward, I'll give you, do you think you can get a response by Thursday?
I think I can. If the court would be willing to entertain Monday, that would make me have a little more breathing room, but I'm pretty confident I can get it done by the end of the day, Thursday, if you want to see it that quickly.
I'm fine by Monday.
Okay.
Yep. We'll set it for Monday. All right, anything else we need to address on the subpoena issues?
I don't believe so.
Okay. And then I was going to meet with counsel in chambers. Is that correct?
Yes.
Okay. All right. Let's go ahead and do that. I'll have counsel come back and we'll be off the record. Court's going to recall 25 CR 136. This is People versus Yvonne Woods. I'm just going to indicate for the record that the court did meet in chambers with counsel. Counsel for the defendant and the people were present. The parties are going to reach out to the division to have the matter set for a change of plea hearing. All right. Next, the court's going to call case number 25 CR 152 and 25 CR 177, People versus Jason Ray. I'll take entry starting with the people.
Amanda Becker and Tony Tarantino for the people.
You want to go to Christopher Richardson on that? Who's in custody?
All right, good morning. This matter is set today for a status conference. The court had previously had the matter heard by another judicial officer in regards to Mr. Ray's request for new counsel. The court found that there was not a conflict which warranted the appointment of new counsel. I was further advised that Mr. Ray had indicated a desire to represent himself going forward. Can I confirm, Mr. Richardson, is that how Mr. Ray wishes to proceed?
Judge, at this time, I believe that to be the case based on the filing that was dated June 4th, 2026. However, there has not been a full Arguello advisement given to Mr. Ray, and so I think we still need to get through that.
Okay. Mr. Ray, can I confirm, are you intending on representing yourself going forward?
I'm working on a motion to file to the court concerning the whole matter.
Okay.
This situation that occurred with Judge McNulty, I filed a motion to the court, and you keep insisting on proceeding without giving a decision to that matter.
Okay.
That matter is the full focus of showing the ineffective assistance of Christopher Richardson.
So,
you are proceeding by violating a canon.
Okay. Mr. Ray, I want to come back. I want to take this one step at a time as we go forward, and I'm going to give you the opportunity to address the court, okay? But I do need to know, are you intending on representing yourself going forward?
I'm explaining it to you, sir.
You're frustrated with the court not ruling on the motion regarding the motions hearing and
Full concern to the ineffective assistance.
I know, but I need to determine how you're going
I
to.
couldn't answer the question because you're trying to force me to go and proceed to a hearing that would require information from that matter to show ineffective assistance.
Okay. So again, I'll just make findings. The court had previously reviewed the transcript of the motions hearing that was held in Judge McNulty's division. The court, in reviewing that transcript, did not see anything that was inappropriate or would warrant this court to believe that there was any deviation from the court's ethical obligations, nothing which would cause this court to believe that there was anything improper which would warrant dismissal of the charges. And so, Mr. Ray, I'm not going to take any additional action on the.
I understand everything you're saying, sir.
Okay.
And the concern is this: the bias action alone regarding what Judge McNulty did is bringing to my full attention his whole hearing is biased.
Okay.
Whether you want to dismiss the case or not, you have to consider how I'm seeing what I seen.
Okay. I need to determine how you're going to proceed, either representing yourself or with counsel. Do you want to represent yourself or do you want to proceed with
I'm
counsel?
showing to you what I would state in what you're saying to Christopher Richardson, and you even watched it while I was sitting in that jury box. He's telling me he don't want to entertain my concerns.
Okay, Mr. Ray, Mr. Ray.
Explain to you the prejudice that he shows.
Please hear me. No, Mr. Ray, I set it for a conflict hearing to address this issue. The court determined there was not a conflict. So that leaves you with one of two options.
Just explain to you.
There's two options. You can proceed representing yourself or you can proceed with Mr. Richardson. That's all we're discussing right now.
No. This is a violation of my due process rights in itself.
Okay.
You're telling me you sent me to see another judge when I'm saying it would require me to show what you just found in your finding of that motion. You didn't give the finding to the motion before you try to force me to proceed.
I need to know how you're going to.
What you're doing.
I need to know how you're going to proceed. Are you going to represent yourself or are you going to have Mr. Richardson remain on your case? If you do not make a decision, Mr. Richardson is going to remain on the case and we're going to proceed forward.
Yeah, I can't have him. I can't. I'm telling you the prejudice.
Then are you intending on representing yourself?
Let me explain the prejudice first.
No, I need to know what your decision is.
What do you mean, no?
I need to know what your decision is, Mr. Ray.
The first time I tried to dismiss Christopher Richardson was behind him agreeing with what a police wrote on an affidavit versus what was shown in body camera footage. He argued with me. I explained it to the judge that did the hearing.
Okay.
We enter preliminary hearings and he refuses to bring that matter to the court's attention.
Mr. Ray, you
prejudice.
have already articulated
No, I
your
haven't
dissatisfaction.
None of that to the judge.
Your dissatisfaction with how Mr. Richardson
And
has
I'm
proceeded.
Prejudice.
Then are you intending on representing yourself?
Yeah, I have to.
Then I'm going to go over an advisement with you. All right, Mr. Ray, do you understand that you have the right to be represented by counsel?
And I'm requesting that right.
Okay.
I'm requesting to have counsel.
Okay. The court is.
I can't have counsel that ain't representing me fully, advocating for me.
You are requesting to have counsel appointed.
With Strickland versus Washington, several aspects that are pointed out, and I will with the motion.
All right, Mr. Ray has
It's that
indicated.
simple. You keep violating my rights, man.
Mr. Ray has indicated a desire to continue. He said he indicated that he wanted representation. The court has previously granted a conflict hearing. No conflict was determined. So at this point, the public defender's office is going to remain appointed on behalf of Mr. Ray. Procedurally, where do we need to go, Ms. Becker?
He's trash.
At this point, are we setting for motions in trial?
Your Honor, yes, the people do have speedy in both cases, and then the people also have a pending motion for joinder for the two cases.
Okay. Mr. Richardson, any position on the motion for joinder?
Judge, we do object to the motion for joinder. At this stage of things, we have been through a 404B hearing, which dealt with some of the underlying facts that would have been kept out under Judge McNulty's prior ruling. So we do object for the record as to that. In terms of proceeding, I think that the Arguello advisement, I think the court still needs to go through those factors to fully flesh out what Mr. Ray wishes to do. I don't think he's been pursuant to the sort of the showing that has to be shown under Arguello. I don't know if I am not sure what Mr. Ray wants to do based on his record.
Okay.
Obviously, this is one of the reasons this was sent over from Judge Ramey's division, but I just think that we need to fully clarify that.
Okay. Mr. Ray, I'm going to go through this one more time.
Listening to your fucking ass, man. You keep fucking disrespecting me. Just heard me tell you, it's fucking president.
I'll have you escort Mr. Ray out. Thank you.
You need to walk on your own then.
All right, I'm going to indicate for the record that Mr. Ray,
Somebody know the deputy.
Why you leaving?
Good, then don't fucking push.
I'm not fighting that.
Don't
You're
push
pushing me,
back.
and I'm fucking telling you.
You're pushing, and I'm pushing you again there because you're not moving. Gonna walk on your own?
I'm walking on my own. What the fuck are you talking about?
Stop fighting then.
Who's fighting with you? I'm in handcuffs, man. How the
Yeah.
fuck am I fighting with
And
you?
you keep turning toward
Come
me.
on, man.
So stop.
Nobody's turning towards you.
Yeah, you are.
Come on, man. Quit pushing on me. You're pushing on me.
all right, I'm going to make a record. Mr. Ray, when the court indicated it was going to go through a further Arguello advisement with him, stood up. Mr. Ray began cursing at the court. He was then escorted out by
I'm trying to give you a direction. You're not listening. So stop. Move around.
Oh, 1106.
All right. We've had a number of interruptions with court records, so I'm going to just start over. The court was intending on going through an additional Arguello advisement with Mr. Ray. Mr. Ray stood up, began cursing at the court, was then escorted out by a deputy. As he was being escorted out, sounds like there was some pushing. A number of deputies had to respond. Mr. Ray has continued to be combative with law enforcement and has expressed a very clear intention of not participating in these proceedings today. So with that, Mr. Richardson, how do you want to proceed at this point?
Judge, I believe we're set for the status conference for 6/22 in the afternoon. Based on the current state of the record, I need to go and attempt to meet with Mr. Ray. I believe that if the public defender is going to remain on the case, we are going to need to set some dates. The posture of the case has created some uncertainties and in terms of defense investigation and funding, things of that nature. I am trying to resolve that hopefully today. So if we can come back on Monday, wishful thinking, but I think worth it nonetheless to see if I can get some sort of indication from Mr. Ray how he wishes to proceed and get dates set.
Okay. We've been advised by the deputies that Mr. Ray should be set off docket for a number of the reasons which I think we saw today. with his behavior in the courtroom. So what I'm going to do is I'm going to continue this for an additional status conference. I'm going to set it off docket. And I could do the 23rd at any time if any of the parties can clear.
Your Honor, I am out after Monday until the 30th, or the 1st rather. Is it possible to perhaps set it later this week?
We could set it. Yeah, I can set it Thursday at 9 a.m.
Works for people.
Okay. I'll address the motion for joinder at that time. Mr. Richardson will have the opportunity to get some direction from Mr. Ray. It's obviously a challenging procedural posture given Mr. Ray's unwillingness to participate in these proceedings. So we'll see where we're at on Wednesday and can go for, did I say Wednesday or Thursday? Thursday.
Thursday.
And then we'll go from there. Is there anything else we need to address today?
Your Honor, just two things for the people. One, the people are not moving on the defendant's pro se motion for discovery unless or until he's determined by the court to be pro se. We will not be sending discovery to him. And then the second thing is we can also discuss this on Thursday, but if Mr. Richardson would like time to confirm, we have speedy trial in the 25 CR 152 matter as October 30th, 2026, and speedy in the 177 matter as November 3rd, 2026.
Okay. Okay. I was just looking. Yeah, at this point, the court's not going to take any action on the motion to obtain discovery, given that Mr. Ray continues to be represented by counsel. Mr. Ray had previously filed motions addressing concerns. The court found them to be procedurally improper as he was represented by counsel. So the court's not changing any orders on any of those motions. All right. Anything else we need to address today?
Not for the people.
Thank you.
All right. We'll be in recess. Thank you.
Notify him, but I do not know. I was going to plan to waive his appearance this morning.
Okay, that's fine with the court. We set this on short notice. Court's going to call case number 25 CR 1392, People versus William Lacer. I'll take entry starting with the people.
Conrad Glover for the people. Zach Ribby for Mr. Lacer. Mr. Lacer is not present. The defense is requesting to waive his appearance for this specific hearing.
All right, I'll grant that request. The matter was set in fairly short order. The people had filed a motion to amend count one. The court has reviewed defense's objection to the motion to amend. I'll note that we have motions presently set on June 18th, and our first day of trial is to begin on July 13th. Mr. Glover, let me go first to you. Any response to the arguments raised in defense's objection to the motion to amend?
Yes, Your Honor. Just one moment. But yes, Your Honor, regarding their objection to the motion to add, I would ask the court grant the motion to amend, motion to amend count one. I guess controlling authority is Rule of Criminal Procedure 7, and it's E. It reads specifically E. The court may permit an information to be amended as to form or substance at any point prior to trial. that's the position we're at. It's a pretty lenient standard. And this was done over a month in advance of trial. The cases that they cite are not super compelling. If you look at Fisher v. People that they rely on quite a bit, that was if I'm not mistaken, a day 3 of trial amendment where it expanded the date range by 6 weeks. That's not even close to our circumstances here. We were over a month in advance of trial. These doctors have been in discovery for a while. The medical records have been in discovery for a while. The new information was the doctors finally stating that this would be considered serious bodily injury. It's not super clear in the affidavit or the motion filed by the defense, but there is the initial incident and then a bunch of medical follow-ups. So if police are not present when someone's at a hospital or getting treatment, there's no SBI form provided to doctors. That's a form provided by law enforcement, and then getting a hold of doctors to talk to them. They are very hesitant and resistant unless and until they have subpoenas or waivers. So once they receive their subpoenas, they finally start answering. And so in preparations for the case, we asked them questions, and I believe in the motion, it stated a few days before we filed our motion to amend, the doctor said that they would consider this serious bodily injury. There's no shock or surprise regarding this. These witnesses have been in discovery. These injuries have been noted. We just finally have a doctor willing to give that opinion. So I don't think the Fisher case is super compelling given the circumstances are not even close to where we're at. And so I think it should be granted. I don't think this court can really there's two parts to the motion. There's the objection, mostly citing Fisher. Then there's the SBI. I don't think this court really can deny because you don't believe it's serious bodily injury. I think that's a question for the jury. The reliance on if the court disagrees or is entertaining that argument, I find the reliance on V. Hill suspicious. That case is the whole reason serious bodily injury was amended. That's a case that said serious bodily injury, a stab to the neck wasn't SBI, and then the legislature went and amended that. There's also a subsequent case, Tipples. After that, it's a citing reference. If the court's in Westlaw, it's a 26 Westlaw 568881 case that differentiates that case. And I even believe Tipples is a strangulation case. And again, saying these facts are similar to Egloff isn't sincere, as that's a case where the victim's nose was broken during a strangulation and no doctor or surgeon was asked to give an opinion on SBI, which is the opposite of what we have here. We have actual, we will have an expert opining to serious bodily injury. We're not going to skip that key element in our direct examination. So I think based off those cases, this court cannot deny it because you don't believe it would qualify as SBI. That's a question for the jury. Obviously, if we make the same mistake as Egloff and don't ask an expert that, I would expect a JOA to be granted on that, but we're not at that posture. And I don't see any authority that would allow this court to submit its subjective interpretation of SBI or not in deciding whether or not to grant or amend. That would be the purpose of a preliminary hearing. Do we have probable cause to proceed on the charge or not? So I think 70 is pretty clear that this is permissive. It's timely. It is not nowhere near similar. The mid-trial amended range or completely new information. So we'd ask the court to grant it and we'll work on setting dates for a preliminary hearing before trial. If the court grants the amendment, I assume they'll demand and we should set for a preliminary hearing.
Okay. One of the factors the court came across in its research was whether or not the people could have saw an earlier amendment. Is this something through the course of discovery the people should have been aware of, or was there any basis for, or is there any basis for an argument that this was something that could have been amended months ago versus a month before trial?
Your Honor, I tried to touch on that a little. This was amended as soon as a doctor would speak to us. We had the medical records. As I stated, no law enforcement officer was present for any of this follow-up. And so doctors just don't randomly sign serious bodily injury forms or put that in medical records. That's a specific form law enforcement usually provides when they see fit. So the people and law enforcement weren't aware is the wrong word, but the victim was seeking medical treatment on her own. It wasn't as if, night of offense, taken, gets medical treatment, police are there. She's seeking follow-up on her own. And after the fact tells us we get these medical waivers and medical records. There's no serious bodily injury designation because that's a legal question that usually law enforcement asks. And like I said, doctors generally ignore us and won't talk to us until we have trial dates and waivers. And so the Dr. Samarna, who we got a hold of and spoke with, was the first doctor willing to speak with us. Once they receive subpoenas and are like, what's this? Why am I needed? Is when they finally start responding to us. So that we've known of the injury, but no doctor or expert had opined as to whether it was serious bodily injury or not until we interviewed that doctor. I could have filed amended charges, but I wouldn't have a real basis to do so without that expert opinion, because no SBI form was previously filled out. No doctor had previously given that opinion. So I believe the motion states the interview with the doctor was completed on May 28th. We discovered that report to the defense and then filed the motion. So the defense got the supplement before the motion to amend was filed. I think that was a difference of a few days. But no, until this doctor decided to speak to us, I could not have amended to include SBI without just estimating or making an uneducated and uninformed opinion. And I wouldn't have survived preliminary hearing because I wouldn't have any basis for serious bodily injury. So, no, previously we did not have this opinion. It was filed shortly after we got the opinion and discovered the serious bodily injury form.
All right, thank you. Mr. Rippey, any addition you want to make to your motion?
Yes, Your Honor. Just responding a bit to the district attorney's argument, we would ask that the court deny the modification of count 1 here. I do think that timing is pretty important here. I would just note, and that's part of the reason why I detailed this in the facts section of my motion, is Mr. Lacer initially continued preliminary hearing to wait on additional medical records. There was some indication that they didn't believe that, or at least at the most it was, quote, unclear about SBI. He continued it out into August. And at that point, too, we went forward on preliminary hearing. There was no further discussion after initial potential mention of SBI. And then we continued through the case. Mr. Lacer ended up bonding out. There was an initial trial setting. No motion to add was filed before that. And then we get to the point where I know the district attorney stated that they wouldn't speak until trial dates were set. There were initially trial dates set for March. There was no indication of the motion to add at that point. And then it was February 2nd when this case was continued out into July. And there was, again, no motion to add up until I believe it was the Friday, the 5th at 4 p.m. Then the endorsement deadline is the 8th. Those other notes did come in, but part of the reason why I detail the information that we did have in discovery is because, frankly, all of that information in conjunction with the case law cuts against SBI, and so it's not as if the named victim in this case had a clear laceration from a knife or a broken bone or something that would clearly indicate SBI. Based on the communication we had early in the case and based on the information present in evidence, and there were no new medical records after those dumps in July of 2025, there was nothing really from the defense's perspective that could have led us to believe that SBI charges would be filed, especially at this stage. I do want to note, and People v. Boatsman is another case I cited. The people are mentioning Fisher, which is something that was amended during trial, but Boatsman is an unpublished case from 2017, which says that the court does still have discretion and may legitimately consider all of these other factors, including the timing, whether charges could have been added earlier, prejudice to the defense. Mr. Lacer, this is a big jump for Mr. Lacer. This is a 2 to 8 with probation eligibility is the initial count 1 now, going to a mandatory 10 to 32 just before trial. This would require consultation with experts about SBI, potential other evidence that we would want to try and introduce or combat, and changes our trial strategy, as well as trial calculation as to whether even to go to trial. And so to put Mr. Lacer in this position at that point, when all of this medical information has been in discovery for close to a year, I do think it's highly prejudicial and was not anticipated at all by the defense at this stage in the case. I did want to also clarify that when the people mentioned V-Hill, that was a stabbing case, and they did change SBI based on that, but it's a completely different type of injury. They were talking about whether or not it had to be actual SBI based on the injury from a stab wound, but then they took that principle and applied it to other cases. Egloff, there was a broken nose, but that's not what was in debate at trial about SBI. As I cited in the motion, there's all of these punctures inside of the throat, and the whole discourse, and I cited some parts of that case as well, is about whether the injuries to the throat could involve life-threatening situations versus whether they actually did. And it is quite on point with this case in terms of the facts. And then there's other cases that apply it to all the other specific types of SBI that could be alleged. And I believe I cited, I think that was Pope was the case there that applies it to protracted loss or impairment of function of any part of the organ or body. And I understand that is more of a legal argument, Your Honor, but I do think it's important to include that here in the totality of what we're discussing as to why these charges were added, because again, I think it's a different situation if there were fractures or other things that were clearly indicated as SBI in discovery, and that's just not the case here.
Okay. All right. Thank you, Mr. Rippey. All right. The matter comes before the court today on a hearing on the people's motion to amend count 1. Count 1 was originally charged as a second-degree assault, strangulation. People's motion to amend seeks to amend the charge to assault in the first degree, alleging serious bodily injury. The court here is to begin first by looking at Colorado Rule of Criminal Procedure 7E, which states that the court may permit an information to be amended as to form or substance anytime prior to trial. Courts should typically construe this rule liberally to avoid dismissal of charges for irregularities. The court should consider the totality of the circumstances in exercising its discretion to allow or disallow amendment of a pleading. Such circumstances may include the timing of the motion, the history of the case, whether the amendment could have been sought earlier, and the potential prejudice to the other party, in this case, defense. The motion to amend was filed on June 5th, 2026. The motions hearing date was set for June 18th, 2026, and we're set to begin trial on July 13th, 2026. So the motion was filed approximately 38 days in advance of the trial starting. The case has been pending since September of 2025. The court inquired of the people whether or not an earlier amendment could have been sought through due diligence. The people have represented that in their trial preparation, they were, for the first time, given the opportunity to speak with some of the treating physicians. It was through these discussions that ultimately the physicians determined that there was serious bodily injury, that new information was learned shortly before the motion to amend was filed. Court also needs to consider any prejudice that would result from amending count 1. Here, the court notes in reviewing its objection to the motion to amend that they've articulated that there would need to be a reassessment of trial strategy, additional investigation, determining whether additional discovery or expert consultation would be needed, and essentially argument as to whether or not, if this amendment is allowed, counsel can be effective and still proceed to the date we have already selected. The court has weighed all of these factors. Again, it is a rule that, based on the court's review of the cases cited, both cited through defense's response, it is to be liberally construed. The court here understands the timing between when the motion was filed and when we are set for trial. However, in weighing all of those factors, ultimately the court determines that the waiver should be allowed. The court's going to grant the people's motion to amend count 1. Count 1 is a preliminary hearing eligible count. Mr. Rippey, how do you want to set on the preliminary hearing?
So, Your Honor, I learned from the people that there may be a witness conflict for the motions hearing on the 18th, which would necessitate a separate preliminary hearing date. I would need to speak to Mr. Lacer about that. I would also need to see, just in terms of timing, if that's something where we need to reassess what we're going to be doing here going forward. And I'm hesitant to set a preliminary hearing date without Mr. Lacer present. I don't know if the date setting could be something that's addressed on the 18th rather than today. But that would be my record for now.
Okay. Ms. Glover?
Your Honor, my preference would be we just set a date. And if it, for some reason, doesn't work, we can address that at the motions hearing. But the defendant already has a active warrant with a cash-only bond. So I think there's a significant chance he will be, if he shows up for the motions hearing, he will be in custody. So I don't think his availability is going to be the deciding factor. Given the current $35,000 cash-only warrant for pretrial noncompliance. So my preference would be to pick a date and set. We could also just wait until Thursday. It's not the biggest delay, but we wouldn't be trying to set in between now and the motions hearing. So I'll defer to the court. I do have conflicts for this witness, so we can either decide now, we can try and pre-clear them with the court's clerk off the record and just wait and see what happens Thursday. Whatever the court prefers, we can do.
Okay. I think given the time between now and when we are set for trial, court's preference would be to set for a hearing date on the preliminary hearing. And I was looking at Tuesday, June 23rd. Court can do any time that day.
I think that is a date that will work for my witness. And let me double check, but I think I can make any time that day work.
Can we do 9 a.m.?
Your Honor, I'm tentatively available, but again, I think just might be subject to change based on what we find out from Mr. Lacer on Thursday.
Okay. We'll maintain the date on the 18th. We'll tentatively clear the June 23rd at 9 a.m. date for a preliminary hearing, and we'll take up any other issues on Thursday. Is there anything else we need to address today?
Not on this case, Your Honor.
No, Your Honor.
All right. Thank you all for your flexibility with getting this set so quick, and we will be in recess.